In this presentation, we will examine the first half of John Paul Stevens' memoir titled Five Chiefs. John Paul Stevens is a former U.S. Supreme Court Justice who was appointed to the court by Republican President Gerald Ford in 1975. It is noteworthy that Stevens was appointed by a Republican president even though he came to be regarded as one of the more liberal justices on the Supreme Court. John Paul Stevens titled his memoir Five Chiefs because in this book he describes personal contacts he had with the last five Chief Justices of the United States Supreme Court. The Chief Justice has often been described as the first among equals. He is equal because, like each of his 8 colleagues, he has only one vote. So to achieve a desired outcome, the Chief Justice must convince as many colleagues to join him as must any other justice. To date, there have only been 17 Chief Justices of the U.S. Supreme Court. Stevens points to the fact that Article 3 of the Constitution provides that judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as Congress shall from time to time ordain and establish. We know that in 1789 Congress passed the Judiciary Act, which formally created the Supreme Court. George Washington appointed all of the members of the court. John Jay would become the first Chief Justice of the U.S. Supreme Court and would serve between 1789 to 1795. In his book, Stevens argues that John Jay stands out as being one of the best leaders to have graced the court during the early republic. John Jay was a Federalist who joined Alexander Hamilton and James Madison in advocating for a strong, centralized government. During John Jay's tenure as Chief Justice, the most important case the court decided was Chisholm versus Georgia. The issue in this case was whether or not a federal court had jurisdiction over a suit brought by a South Carolina citizen against the sovereign state of Georgia. By a vote of 4-1, the 5 sitting justices on the Supreme Court held that the state was subject to a suit in a federal forum and that jurisdiction had been conferred by Congress in the Judiciary Act and was also consistent with Article 3 of the Constitution. The Chisholm decision was not welcomed by states saddled with enormous debts. In his book, John Paul Stevens argues that John Marshall, the 4th Chief Justice of the U.S. Supreme Court, also stands out as being one of the best Chief Justices. Like John Jay, Marshall was also a Federalist and advocated for strong centralized government. The quantity of Marshall's judicial output is also impressive. He participated in over 1,000 cases and authored more than 500 court opinions. His most famous opinion is undoubtedly Marbury v. Madison, the first case in which the court held an act of Congress to be unconstitutional. And in subsequent cases, the Marshall Court upheld the power of Congress to establish a national bank. The Marshall Court always made rulings which protected interstate commerce from burdens imposed by state laws, even when Congress had not enacted any federal laws dealing specifically with that matter. In his book, John Paul Stevens is also quite complimentary of the 10th Chief Justice, William Howard Taft. As you may remember from the book Building the Judiciary, Chief Justice Taft persuaded Congress to adopt the Judiciary Act of 1925, which reduced the categories of cases in which the Supreme Court must hear appeal. Taft also argued successfully for the construction of the Supreme Court building, which was completed in 1935, 5 years after his death. In his book, Five Chiefs, Stevens is also quite complimentary of Charles Evans Hughes, who would serve as the 11th Chief Justice of the United States Supreme Court between 1930 to 1941. Hughes' tenure as Chief Justice began during the Great Depression and it included the first 2 terms of Franklin Delano Roosevelt's presidency. Immediately after FDR took office, Congress enacted a number of far-reaching statutes, and the Supreme Court initially declared the early New Deal legislation to be unconstitutional. When FDR threatened to pack the court with 6 new justices, it was Chief Justice Hughes who lobbied against this to the Senate Judiciary Committee. The committee ultimately listened to the Chief Justice and did not permit FDR to pack the court with justices who would vote in favor of his New Deal legislation. Ultimately, Chief Justice Hughes and the majority of his colleagues would uphold the constitutionality of FDR's economic proposals. Next, John Stevens tips his hat to Harlan F. Stone, the 12th Chief Justice of the U.S. Supreme Court. Stone was named the Chief Justice in 1941 by President FDR. As an earlier Associate Supreme Court Justice, he had supported FDR's economic proposals even at times when the majority of the court did not. Stone was a legal scholar, and on more than one occasion he would be the lone dissenter in a case, only to be joined by the majority a few years later in a similar case. In this respect, Stone was ahead of the legal curve. Interestingly, the Constitution does not impose any qualifications on U.S. Supreme Court justices, but Article 1 of the Constitution mandates that the Chief Justice shall preside at any trial by the Senate of an impeachment of the President of the United States. Throughout U.S. history, only 2 presidents have been impeached. President Andrew Johnson and Bill Clinton were impeached by the House of Representatives but acquitted by the Senate. During Clinton's impeachment proceedings, the Supreme Court Justice William Rehnquist presided. The Chief Justice is paid $223,500, which is only about $10,000 more than each of the other Supreme Court justices. Yet he is responsible for much more work. Once the court has deliberated and decided a case, the senior justice in the majority, most often the Chief Justice, assigns either himself or another justice in the majority the task of writing an opinion explaining the result. After receiving this draft, each justice provides suggestions and changes. They may also prepare a dissent or a separate concurring opinion, or simply join the circulating draft. The Chief Justice also administers the oath of office to the President on Inauguration Day. And as this picture will show, in 1861, Chief Justice Roger Taney actually administered the oath of office to President Abraham Lincoln, in spite of the fact that they were rivals. Also, as mentioned earlier, the Chief Justice assigns the writing of opinions that explain why litigants have won or lost their case. When the Chief Justice is in the dissent, the senior justice in the majority makes the assignment. The Chief Justice also serves as the circuit justice for 3 of the 13 United States Courts of Appeals. The Chief Justice also presides over the Judicial Conference of the United States, which is a policy-making body for the federal judiciary. The Chief Justice also oversees relationships between the federal courts and their sister institutions. He is the top federal judicial officer, and he will often play host to the many foreign dignitaries who visit the court. After graduating from Northwestern University Law School in 1947, John Paul Stevens became a law clerk for the United States Supreme Court Justice at a salary of $5,400 per year. As part of that experience, Stevens had personal interactions with Chief Justice Fred Vinson. Vinson is the first of the 5 chiefs that Stevens is making reference to in the title of his book. President Harry Truman, a Democrat, appointed Fred Vinson as Chief Justice to the United States Supreme Court in 1946. His appointment came at a time when the Supreme Court was deeply fractured, both intellectually and personally. Some of the justices would not even speak to one another. Vinson was credited with patching this fracture, at least on a personal level. In April of 1952, President Truman informed Chief Justice Vinson of his intention to seize control of steel mills. Chief Justice Vinson assured the president that the seizure would be legal under his executive powers and that a majority of the court would support it. However, in June, 2 months after the president issued his executive order, the Supreme Court declared in Youngstown Sheet and Tube versus Sawyer that Truman had acted unconstitutionally. Vinson disagreed with the court in this 6-3 case, and he wrote a dramatic dissent. According to Stevens' memoir, Chief Justice Fred Vinson was by no means the intellectual leader of the court during his day. Vinson was also not much of a writer, and he gave his law clerks very few instructions about how they should write drafts of his opinions, though Vinson was very clear about the result that he wanted. In his time on the Supreme Court, Vinson wrote 77 opinions for the court and 13 dissents. Also, Chief Justice Fred Vinson swore in Harry S. Truman and Dwight D. Eisenhower as presidents. And Fred Vinson is the last Chief Justice to be appointed by a Democratic president, namely Harry Truman. As John Paul Stevens shall explain in the second part of his memoir, all of the subsequent Chief Justices, Earl Warren, Warren Burger, William Rehnquist, and John Roberts, were appointed by Republican presidents. Next, John Paul Stevens turns to a discussion of Chief Justice Earl Warren, who was the 14th U.S. Supreme Court Justice between 1953 to 1969. During Earl Warren's entire tenure as a Chief Justice, John Paul Stevens practiced law in Chicago. Therefore, he writes about Warren primarily as an observer rather than a participant. Still, when he was an attorney, Stevens did argue a case in front of Warren and the rest of the U.S. Supreme Court justices. The Warren Court is known primarily for its progressive decisions, including Brown versus the Board of Education, as well as several decisions which were applauded by inmates' rights advocates. Interestingly, this week there is a supplemental article for you to read which suggests that Earl Warren's own extensive experience as a former prosecutor may have influenced his decision in these cases. Though his liberal opinions motivated impeach Earl Warren campaigns by hostile stateside critics, Earl Warren earned the respect of Presidents John F. Kennedy and Lyndon B. Johnson. In fact, after Kennedy was assassinated, Earl Warren was assigned by Lyndon B. Johnson to investigate the assassination. As the Chief Justice, Earl Warren helped to end school segregation and transformed many areas of American law, especially regarding the rights of the accused. He made the court a power center on a more even basis with Congress and the presidency. In the next lecture, we will explore the remaining 3 chiefs of the United States Supreme Court.